Good day, class. Welcome to chapter 2 of partnerships. So this is obligations of the partners. We'll be talking first about section 1, which is obligations of the partners among themselves. So what are the relations created by a contract of partnership? Number 1, it is relations among the partners themselves. Number 2, relations of the partners with the partnership. Remember, class, no, a partnership has a separate personality, distinct from the partners. No? Number 3, relations of the partnership with third persons with whom the partnership contracts. And number 4, relations of the partners with such third persons. So now we'll be focusing more on the relations among the partners themselves. So let's talk about commencement of a partnership. When does a partnership contract commence? Let's remember, class, no, a partnership is a consensual contract, meaning it exists from the moment of the celebration of the contract by the partners. You don't need any written contract para magsimula ang partnership. The moment there is consent among the partners to create a partnership, then the partnership already commences. Nagsisimula na yung partnership kapag meron ng consent ng mga partners. Now, let's talk about the power or right of a partner to terminate the partnership. Any one of the partners can dictate a dissolution of the partnership at will, provided that he acts in good faith. Dissolution must not be made at an improper or unreasonable time. So class, kapag mayroong partner sa partnership na ayaw nang tumuloy sa partnership, hindi naman siya pwede pilitin. Because that will be like involuntary servitude, no? You can always, the partner can always desist from joining the partnership, provided that there is no bad faith involved. So magiging sobrang importante, class, sa law, no? Ang bad faith at saka good faith. It will determine a lot of things, no? If such partner who wants to dissolve the partnership acts in bad faith, the partnership shall still be dissolved, but he or she shall be liable for damages. So yun, class, no? Kasi pag may ayaw talaga, pag may umalis na partner, once there is a change in the relation of the partnership, the partnership is dissolved already. Once there is a change, once there is a change in relation among the partners, the partnership is dissolved. Kung may namatay, kung mayroong umalis, or kung may bagong sumalid na partner, the old partnership is dissolved. All right? There is no such thing as an indissoluble partnership. No? Hindi pwedeng sabihin ng mga partners na sa ayaw at sa gusto mo, magiging partner ka habang buhay ka. Hindi pwede yun. Okay? Obligations of the partners with respect to contribution of property. So the obligations are, number 1, to contribute at the beginning of the partnership or at the stipulated time the money, property, or industry which he may have promised to contribute. Number 2, to answer for eviction in case the partnership is deprived of the determinate property contributed. So what is eviction, class? Now we will talk more about this in the coming slides, no? Pero let me give you a brief background. Itong warranty against eviction, makikita to sa law on sales, no? For example, nagbenta ako sa iyo ng lupa, no? Na yung pala meron palang ibang tao na mas may karapatan sa lupa na yon. So ano nangyari? Kinasuhan ka ng taong yon. So dahil kinasuhan ka, nawala sa iyo yung lupa. Ngayon, pwede mo akong kasuhan doon, class, no? So in the same way, no, pag yung partner nag-promise siya na mag-contribute siya ng lupa, tapos nawala yung lupa dahil kinasuhan ng third party, maging liable yung partner na nag-promise na mag-contribute doon ng lupang yon. In case of delay, to answer for the fruits of the property which he or she delayed contribution thereof. So class, na it's very important sa partners na pag nag-promise sila na magko-contribute sila, they have to really contribute kasi pre-promise nila yon. Alright? Kailangan pa ba mag-demand para magkaroon ng interest? Hindi, no? Let's remember the general rule, no? Kapag there is no demand, there is no delay. it does not apply it does not apply to contribution of properties to a partnership. The moment na na-delay ka, no, kahit ordinary delay, you are already liable for the fruits, no, ng property. Number 4, to preserve the said property with the diligence of a good father of a family pending delivery. So, ibig sabihin, bago ma-deliver yung property sa partnership, dapat alagaan ng partner, no, with the diligence of a good father of a family, yung property. Hindi na pwedeng iiwan kung saan-saan, yung naaarawan, yung nababasa. Dapat alagaan niya to, no? Number 5, to indemnify the partnership for any damage caused to the property in case of delay. The property contributed by a partner to the partnership becomes property of the partnership. Sabihin nito, the contributed property cannot be withdrawn or disposed of by the contributing partner without the consent or approval of the partnership or of the other partners. So once binigay mo na yan, no, once you transfer the ownership of that property to the partnership, it belongs to the partnership. All right, class? Paano kapag ang kino-contribute mo for say, for example, is your office space? Dapat ba i-transfer mo yung ownership ng office space mo? Well, kapag ang kino-contribute mo is yung use lang ng office space. If what you're contributing is only the use thereof. All right? Hindi kailangan malipat yung yung ownership dun sa partnership mismo. All right? But we will talk about that in the next slides, no? But the point here is pag nag-contribute ng mga partners ng property sa partnership, hindi siya basta-basta pwedeng kunin na lang ng kung sinong partner. All right? Because it belongs to the partnership. So kung partners na kukuha niya, it needs the consent or approval of the other partners. So what is the effect of failure to contribute property promised? Number 1, the partner automatically becomes a debtor of the partnership even in the absence of demand, no? So hindi nag-a-apply dito yung general rule na no demand, no delay, no? Kasi kasi liable din yung partner sa fruits. All right? The remedy of the partnership or the other partners is to file an action for specific performance, which is to collect from the defaulting partner who failed to contribute with damages and interest from the defaulting partner. So dito, hindi kailangan hindi kailangan ng demand, no? Para maging liable yung partner sa damages at saka interest. Rescission or cancellation of the contract of partnership is not allowed unless there is fraud or misrepresentation committed by the partners. All right? So hindi sabihin dahil may na-late, no? Or dahil hindi nag-contribute yung partner dun sa partnership, ibig sabihin wala na agad partnership contract. Hindi yun ang ibig sabihin nun, no? Ang mangyayari doon, pwede siya kolektahin, no? Kakasuhan siya ng ibang mga partners para makuha yung property na prinomise i-contribute ng partner na yun. So what is the liability of the partner in case of eviction? So what is eviction, class? No, according to the law on sales, eviction takes place whenever by final judgment, the buyer or vendee is deprived of the whole or part of the thing purchased. So yung example ko kanina, no? So for example, bumili ka ng lupa sa akin. Tapos yung lupa pala na yun, apparently, mas may karapatan yung ibang tao. It always happens in land transactions, class, no? Yung pala, let's say, kunwari, nag-double sale ako. Hindi kailangan lupa yan. Pwedeng any other thing, no? Let's say, nag-double sale ako. You will learn more about double sales sa oblique 1 at saka sa law on sales, no? Let's say, nag-double sale ako, may binantahan ako, tapos may binantahan din akong iba, no? Tapos let's say, binantahan kita, tapos kinasuhan ka nung isa pang tao na pinagbentahan ko. Tapos napaalis ka. You are ordered by the court to deliver the property to that person. I would be liable to you, no? Kasi merong warranty against eviction. So dito rin sa sa contribution ng partner, let's say nag-contribute siya ng lupa, tapos yung lupa nawala kasi may nagkaso na ibang tao na mas may karapatan pala siya dun sa lupa na yon. That partner, yung partner na nag-contribute ng lupa, hindi na pwedeng sabihin, teka, hindi ko kasalanan yan. No? Kasi korte ang nag-utos na i-deliver yan sa taong yan. Dapat hindi ako mananagot. Hindi pwede yun. Mananagot pa rin yung partner. No? Kasi in case of eviction, liable pa rin yung partner na nag-promise mag-contribute nun or yung nag-contribute na nun, no? So merong liable siya in case of eviction. The partner is bound in the same case as the seller or vendor is bound to the buyer or vendee who was evicted. Liability of partner for fruit of property in case of delay. So here, no demand is necessary to put the partner in default or delay. If you remember in Oblicon, the general rule is no demand, no delay. Ibig sabihin kung let's say pinag-usapan nyo magbabayad ka ng 10,000 pesos after 10 days, tapos tapos yun lang, no? Hindi ibig sabihin hindi ibig sabihin na kapag lumampas na sa date na yon, pa-reliable ka na agad for interest or for damages whatever, no? So dapat kasi gagawa muna ng demand. Dito hindi kailangan ng demand when it comes to a partnership, no? When it comes to the contribution by a partner in the partnership. So from the moment of failure to contribute what was promised, the partnership fails to receive the benefits which the said contribution ought to produce. So ito yung dahilan, no? Kaya for example, let's say ang promise ng partner is to contribute his land, no, na punong-puno ng mga fruits. Para sabihin natin gano'n. As in literal fruits, for example, apples, no? Tapos nagkaroon ng mga harvest. Tapos let's say for example, dapat April pa lang na deliver na ng partner yung land with the apple trees. Eh hindi niya dineliver, no? Parang kinanya pa rin. Tapos let's say dineliver lang niya mga August. No? So from April to August, he is liable. That partner is liable for the value of the fruits. No? That could have been produced kasi dapat nasa partnership na 'yon. All right. Liability of partner for partnership money converted to personal use. So the liabilities are, number 1, to reimburse the amount to the partnership. Number 2, to pay agreed or legal interest of 6% until he pays such amount. No? Itong rate class na 6% legal interest, this is per annum, no, or per year. Okay, that is the rate per annum, 6%. Since 2013, no, that has been the legal interest as of today. And the third liability is to indemnify the partnership for the damages caused to the partnership. Kasi if you're a partner class in a partnership, no, meron siyang fiduciary relationship. You are keeping partnership money or properties, no, in trust for the other partners and for the partnership. So di mo yan pwede gamitin for your own personal use. All right? You have to, but you're considered a trustee of the partnership. So yung partnership money, hindi mo pwedeng solohin lang yan para sa iyo. You have to account for that to your other partners. So what are the obligations of an industrial partner? Number 1 is to render exclusive work for the partnership. Class, by now, dapat alam nyo kung ano yung industrial partner. No? An industrial partner is a partner who contributes only his industry. Alright? Pwede mo magkaroon class ng partner na capitalist partner at the same time he renders his services? Yes, pwede naman yun. No? So so render exclusive work for the partnership unless permitted expressly by the partnership that he can also work elsewhere and put up his own business. The partnership acquires an exclusive right to avail of the industrial partner's industry. Kapag let's say sumuway yung industrial partner. Let's say nagtayo pa rin siya kahit bawal. No, pwedeng kunin ng partnership 'yon. No? An industrial partner cannot engage in business for himself. So prohibition against engaging in businesses. No? Number 1, as regards an industrial partner, the prohibition applies whether or not the industrial partner engages in the same kind of business the partnership is in. This is to ensure faithful compliance by the industrial partner with his obligation to the partnership. So class, if you're an industrial partner, kahit anong business, Hindi mo pwedeng pasukin because you have to devote your time to the partnership. Alright? So kapag industrial partner ka, ganyan, you really have to devote your time and all your efforts for the partnership, no? Number two, kapag capitalist partner naman, the prohibition only applies to any business which is of the same kind of business the partnership is in. So klase pag capitalist partner, bawal lang siyang magtayo ng business kapag kapareho ng business ng partnership. Let's say ang business ng partnership ay computer shop. O yung capitalist partner, bawal magtayo ng computer shop. Pwede ba magtayo yung capitalist partner ng laundry shop? Pwede. Because it's a different kind of business. Eh yung industrial partner ba? Let's say ang business ng partnership is computer shop. Pwede ba magtayo ng laundry shop ang industrial partner? The answer is no. All right? So if you are an industrial partner, you really have to devote your time to the partnership business. What are the remedies when the industrial partner engages in business without the express agreement of the partnership? Number one, the other partners may exclude him from the partnership, or number two, the other partners may avail themselves of the benefits which the industrial partner may have obtained. Right? Let's say nagtayo yung industrial partner ng negosyo na walang consent, no? Na walang permission ng ibang mga partners. Pwede siya tanggalin sa partnership, no? Isa pa, pwedeng kunin ng partnership yung kinita, no? Yung kinita ng industrial partner. That's what the law provides, class, no? So kahit let's say nagpagod yung industrial partner sa business niya, pwede yung profits doon pwede kunin ng partnership. In all cases, the other partners have a right to damages. When is there an obligation of a capitalist partner to contribute additional capital? In case of imminent loss of the business, and there is no agreement to the contrary of contribution of additional share to save the business, the capitalist partner must contribute additional capital. So paano class, no? Let's say nalulugi yung business and the only way to save it is to contribute additional capital. Ano mangyayari doon? Dapat yung lahat ng mga partners, no? Dapat lahat ng mga capitalist partners, capitalist partner class lang, no? Capitalist lang, hindi industrial. So lahat ng mga capitalist partner, they are obliged to contribute additional capital to the partnership para ma-save yung partnership. Paano kapag ayaw nila? So ito, if he or she refuses, he or she can be obliged to sell his or her interest to the other partners. Kapag ayaw mo magbigay ng additional capital, benta mo sa akin yung share mo. Benta mo sa ibang partners. Alright? Kapag ayaw, mag-contribute ng additional capital. No? And it only applies when there is an imminent loss of the business. And the only way to save it is to contribute additional capital. No? So obliged yung mga capitalist partners na magbigay, no? Based dun sa amount na kailangan. So kung ano yung amount na kailangan, it depends on the circumstances. What are the requisites in obliging the capitalist partner to sell his share to the other partners? Number one, there is an imminent loss of the business of the partnership. Does it always happen, class? Well, it often happens, no, in a business, especially now during the COVID pandemic. Ang daming businesses na nagsasara. Alright? Nagsasara kasi tuloy ang bayad nila sa rent, ganyan. Tapos wala masyadong customer, lalo na during ECQ. Number two, majority of the capitalist partners believe that an additional contribution to the common fund will save the business. A perfect example, no? Paano kapag wala na pang bayad ng renta yung partnership business, and the only way to save the business is to have more capital, to have additional funding. So dapat magbigay talaga yung capitalist partners ng additional funding. The capitalist partner, number three, no? The third requisite is the capitalist partner deliberately refuses to contribute an additional share to the capital. Yung talagang ayaw niya, no? Deliberately nire-refuse niya So talagang wala, basta ayaw lang niya, no? Ayaw niya maglabas ng pera to save the business. And number 4, there is no agreement that even in case of an imminent loss of the business, the partners are not obliged to contribute. Pero teka, saan ba makikita yung agreement na yan? O dapat yung agreement na yan, nasa simula pa lang ng partnership. No? So dapat kung nasa articles of partnership yan, edi maganda, no? Kasi malinaw. Alright? Ang hirap naman kasi kapag kapag kung kailan na nalugi, saka mo sasabihin, "Uy, teka, may agreement tayo na walang contribution additional capital." That's hard to prove actually, no? So ito klase yung requisites, no, in obliging the capitalist partners to sell his shares to the other partners. Yung kapag talagang ayaw niya magbigay ng additional contribution to save the business. What is the obligation of a managing partner who collects debt? So the general rule is, if the managing partner has a personal credit against a debtor who is also a debtor to the partnership, any sum received by the managing partner shall be applied to the two credits in proportion to their amounts. So class na sinasabi dito, no? For example, partner ako sa isang partnership, no? Tapos nagpautang ako kay B or kay A na lang. Nagpautang ako kay A. Si A pala may utang din sa partnership. But class, remember, managing partner ako. I can't be just any partner. I have to be a managing partner. So class, ibig sabihin, kasi itong si A, kapag magbabayad siya sa partnership, kanina siya magbabayad? Well, most likely sa akin because I'm the managing partner. Let's say ang utang nung ni A sa akin ay 100,000 pesos. Tapos ang utang ni A sa partnership ay 200,000 pesos. No? So yun, no? Tapos kulang na pambayad si A para bayaran ako at saka yung partnership. Alright? Let's say ang pera lang niya is 50,000 pesos. O kunwari, ganun. So, yung 50,000 pesos, let's say, sabi ni A, kunwari, Mr. Attorney Lagman, gusto ko bayaran yung partnership, ayoko muna kita bayaran. Pwede ba akong humindi doon? Sabi ko, teka, dapat sa akin muna yan. The answer is no. Kasi pag yung debtor na mismo, si A, kapag sinabi niya na gusto niya bayaran muna yung partnership, no? Pag sinabi niya gusto muna niya bayaran yung partnership, yung buong 50,000 pesos na yon, sa partnership na utang i-apply yon. So class, imagine that, no? So ako kasi, we have to act in the best interest of the partnership. Kahit so kapag sinabi nung debtor, sa partnership i-apply yan, talaga yung sa partnership i-apply yung buong amount. Paano kapag hindi ganon? Paano pag sinabi niya, Attorney Lagman, dahil gusto kita, mabait ka, yung buong 50,000 pesos, sa utang mo natin i-apply. Gusto ko sa utang mo i-apply. Ako naturally class, no? Dahil babayaran ako, naturally gusto ko na yung buong amount na yon sa utang ko i-apply, pero hindi pwede yon. No? So class, no, sinabi na mismo ng debtor na gusto niya na sa akin bayaran yung buong amount na yon. Hindi pwede yon. Right, no? Hindi pwede yon. Kahit sinabi niya na yung buong amount na yon ay sa akin lang mapupunta, dapat magpo-proportion pa rin. So magkano? Paano ba natin i-compute yung proportion? So ganito, class, no? Magkano ba yung utang sa akin ni A? 100,000. Magkano yung utang ni A sa partnership? 200,000. Magkano yung total nun? The answer is 300,000. So ano yung proportion ng utang? Ano yung ratio and proportion ng utang sa akin? So class, no, in the law of partnership, dapat magaling kayo sa ratio and proportion. So you have to apply counting math, no? But I'm sure kaya-kaya din naman to. So 1/3 yung utang sa akin, tapos 2/3 yung utang sa partnership. Magkano yung binigay sa akin? 50,000 pesos. So what is 50,000 pesos times 1/3? Teka, mag-calculator tayo para sigurado. 50,000 pesos Divided by 3, no? 50,000 pesos times 1/3. The answer is 16,667 pesos. Yun yung amount na na i-apply sa utang sa akin. Sa partnership naman, anong answer? Di 50,000 pesos times 2/3. All right? And the answer there is 33,333. That is class no? I-apply tong ratio and proportion kapag ang sinabi nung debtor, teka, gusto ko sa sa managing partner lang i-apply yung utang. O kaya basta, or pag let's say walang usapan, basta nagbigay na lang ng pera. Basta pag nagbigay na lang ng pera, tapos may utang sa managing partner at saka sa partnership, mag-ratio and proportion pa rin. Hindi ibig sabihin, hindi naman dapat na sa partnership lang yon. Magiging sa partnership lang yan kapag sinabi nung debtor mismo na gusto ko i-apply yan sa partnership. Alright? So this is the exception class, no? Medyo na-explain na natin, no? If the money is paid on the account of the partnership's credit only, the whole amount shall be paid to the partnership's account only. All right? And the debtor has the right to choose, no? Kung kanino i-apply yung debt. So this is the exception to the exception. The debtor is given the right to prefer payment to the managing partner if the credit of the managing partner is more onerous or more burdensome to the debtor. For example, the debt to the managing partner has a higher interest rate than the debt to the partnership. What if yung utang sa akin, class, yung pala, ang interest rate ko is 20% per year kasi gahaman ako. Yun. Tapos ang utang sa partnership is 7% per annum lang. Naturally, class, pag ganun, masyadong burdensome naman para dun sa debtor kung pipilitin pa na mag-ratio and proportion. In that case, class, pwedeng i-apply yung buong amount na 50,000 pesos sa akin. Kasi mas burdensome. Alright? But class, remember, that is the exception to the exception. Always remember the general rule here. Okay, remember the general rule. And this only applies, class, to managing partners. Obligation of a partner who receives partnership credit when other partners have not received theirs, and then the debtor becomes insolvent. The partner who receives the partnership credit must bring back the amount to the partnership or share it with the other partners, even if he gave a receipt for his share only. It is because there is a community of interest among the partners. Okay? So, dito, class, no, hindi na nag-apply dito yung managing partner. It applies kasi dun sa previous article. In this article, class, no? So kapag merong partner na binayaran, no? Tapos kahit na nag-apply lang yun sa share niya, yung partner na yon, he has to account it for all the other partners. I-share niya dapat yon sa iba pang mga partners. That is when the debtor becomes insolvent. And we know what insolvent is. Hindi ibig sabihin ng insolvent, walang pera. Ibig sabihin ng insolvent, mas malaki yung liabilities kaysa sa assets. Alright? Yun ang ibig sabihin ng insolvent. So let's talk about risk of loss of things contributed after delivery to the partnership. So class, let's remember in oblicon the rule of res perit domino. The thing perishes with the owner. So class, let's not forget the concepts that we learned in oblicon. Number one, determinate things which are not fungible and where only the use is contributed. So class, what is fungible? We learned in oblicon, no, na ang fungible, ito yung things na may measure na they are exactly identical to all other things that have the same measure. For example, ang example niyan, oil, or let's say bigas, no? Isang bigas ng or let's say isang kilo ng dinorado rice, assuming na same brand sila, no? Kapareho ng isang kilo ng isa ring dinorado rice. Makikita niyo yan sa palengke, class, no? Let's say bibili kayo ng bigas, no? Paano ba binibili ang bigas? Hindi naman yan butil-butil. Binibili ang bigas, kinikilo yan, di ba? Pag bibili ka pa sa palengke, sinasabi mo ba, ay pabili ng isang kilo ng bigas. Gusto ko itong nasa banda rito. Sasampalin ka na nagbebenta, class, kasi pare-pareho lang naman yan. 'di ba? Kahit saan siya dumakot ng ng 1 kilo dun sa sakong 'yon or dun sa lalagyan na 'yon. So yun ang fungible things, class, no? So number one, determine the things which are not fungible and where only the use is contributed. So in this case, class, no, the partner bears the risk of loss because he remains the owner, and by virtue of legal concepts, no, by virtue of the legal concept of res perit domino, the partner bears the risk of loss because siya pa rin yung owner. Kasi ang kinontribute lang niya sa partnership ay yung use ng ng determinate thing na yon. Kasi pwede yung klase, let's say ang contribution ng partner is yung paggamit ng kotse niya or paggamit ng office space niya, paggamit ng bahay niya. Pwede yan, class. Pwede naman na use of rock lang. Ibig sabihin ng use of rock, yung gamit lang. Pero yung ownership nito, nasa partner pa rin. So class, no, paano, let's say ang contribution ng partner ay ipagamit yung kotse niya, tapos nasunog bigla yung kotse niya or na-carnap, who bears the risk of loss? Yung partner lang. Alright, hindi kailangan hindi kailangan na i-bear ng partnership yung loss ng kotse. Ibang usapan kapag ang ginawa ng partner is kinontribute yung kotse tapos nilagay na sa pangalan ng partnership. Kasi yung ownership ng kotse binigay na sa partnership. Pag ganoon na nangyari, partnership na maging liable sa loss na yan. Partnership yung magsasuffer ng loss. So class, I hope that's clear, no? Iba yung yung kapag ang kinontribute lang is the use, at saka kapag yung ang kinontribute is the ownership of the thing itself. So yun, no? So number one, kaya yung partner yung nagbe-bear ng risk of loss kasi siya pa rin yung owner. So number two, determinate things which are transferred in the name of the partnership bears the risk of loss by virtue of res perit domino. The thing perishes with the owner. Kasi partnership na yung may-ari ng determinate thing. Number three, fungible goods or things which are perishable or cannot be kept without deteriorating. The partnership bears the risk of loss even if only the usage is contributed because those things are consumed every time they are used. Example niyan, mga kunwari liquid soap or bigas, no? So you be imaginative with with fungible things, no? Or yung things which are perishable. Alright? Kasi hindi naman niya pwede itago ng matagal. So pag ganyan, ang nagbe-bear ng risk of loss niyan, yung partnership. Let's say nasunog yung mga yan or nag-earthquake tapos nasira, etc., etc. So yun yung mga kinds of loss, no? Yung kapag nawala na. So kapag fungible goods ang pinag-uusapan or perishable goods, or those that cannot be kept without deteriorating, the partnership bears the risk of loss. Number four, class, again, you have to remember, no? This applies to things that have been delivered already. Lahat ng mga bagay na to, pag hindi pa sila dinedeliver, pag ang may possession pa is yung partner, tapos biglang nawala, the partner shall bear the risk of loss. Alright? Kasi wala pa naman sa partnership eh. Itong 5 rules na to, it only applies kapag na-deliver na yung bagay doon sa partnership. Pag na-deliver na yung thing sa partnership. But prior to that, pag nasa kamay pa ng partner yan, the partner bears the risk of loss. Alright? Number 4, things contributed to be sold. The partnership bears the risk of loss. Things brought and appraised in the inventory. The partnership bears the risk of loss. And gaya na sabi natin, class, no? Before delivery of the goods or things, the contributing partner bears the risk of loss. So what are the rules for distribution of profits and losses? So what are profits, class? No? Ang profits, ito yung mga kita, no? Yung mga tubo, yung kinita ng partnership. So the first rule is, the partners share the profits according to their agreement. So class, importante talaga may agreement. Paano kapag walang agreement dun sa profit sharing? Ibig sabihin ba walang partnership? The answer is no, may partnership pa rin. But we will get there, no? Kung paano yung hatian kapag walang agreement sa profit sharing. Alright? So again, class, remember this, no? Ang first rule talaga is kapag mayroong agreement sa profit sharing, susundin yon. Susundin yung gusto ng mga partners. Any agreement to exclude one or more partners from any share in the profits is void. No? So hindi pwede sabihin na ito si partner na to, hindi siya pwede mag-share sa profits. Bawal yun, class. Alright? Bawal yun. For example, A, B, and C formed a partnership whereby each of them contributed 100,000 pesos. So itong tatlo, nagbigay ng tig 100,000. They agreed to distribute profits among them at a ratio of 20%, 20%, and 60%, respectively. The partnership realized profits in the amount of 100,000 pesos. So paano yung hatian? Si A, B, and C shall receive 20,000 pesos, 20,000 pesos, and 60,000 pesos respectively. So class, alam ba natin kung paano na-compute yan? Well, it's very easy, no? Given na yung ratio. So 20% times 100,000 para kay A, edi 20,000. 20% para kay B, so 20% times 100,000 is 20,000. 60% times 100,000 is 60,000 pesos. So class, kung mapapansin nyo, hindi siya pantay-pantay. Hindi ba unfair yon? Well, yun yung agreement class ng partners eh. Paano ko yung isa 10%, yung isa 10%, tapos yung pangatlo 80%? Pwede ba yon? Yes, pwede pa rin yon, class. Alright? Susundin mo yung agreement ng mga partners. Meron lang exception, class, no, kapag manifestly inequitable. Kapag sobrang imposible na yun yung agreement. But class, of course, you have to prove that. Alright? You have to prove na talagang kumbaga para meron ng fraud or meron ng ganyan, no? Merong vitiation ng consent. Ibang usapan yun kapag ganun. Kapag manifestly inequitable yung sharing. But you have to prove that. But other than that, the general rule is you follow the agreement. Kung may agreement yung mga partners, hindi sundin yun. Nangyayari ba, class, na mas malaki palagi yung shares ng ibang partners? The answer is yes. No? Kasi posibleng sila yung gumagawa ng lahat. Yung ibang partners nakikiride lang. So, what if there is no agreement, no? Nasa profit sharing pa rin tayo. The share of each capitalist partner shall be in proportion to his capital contribution. This is the presumed will of the partners. So class, no, pag walang agreement sa profit sharing, ibig sabihin ba they will share equally? The answer is no. Kalokohan yun. Alright? Ang susundin mo, no? Ang susundin yung ratio ng contributions ng bawat capitalist partner. Yun ang susundin na ratio. For example, yung isang partner let's say dalawa lang yung partner sa partnership. Yung isang partner ang binigay niya 90% ng partnership capital, yung isa 10% lang. No, 10% lang yung contribution niya. Fair ba yun kapag equal sharing sila? O kapag yun yung agreement nila, edi sige, kasi may agreement sila eh. Paano pag wala silang agreement? O edi pag ganun, edi ratio and proportion based on the contribution to the partnership capital. Alright? Paano kapag merong industrial partner? Masusukat mo ba yung trabaho niya? The answer is no, not really. Hindi mo masusukat yung trabaho niya. So kapag merong industrial partner tapos walang profit sharing, the industrial partner will first receive a just and equitable share. It is not fixed because it is difficult to ascertain the value of services of a person. Totoo yan, class, no? Paano mo masusukat talaga ang trabaho ng isang tao? No? Mahirap yan. For example, class, no, A, B, and C formed a partnership whereby each of them contributed 200,000 pesos, 300,000 pesos, and 500,000 pesos respectively. Magkano total yan? Hindi 1 million pesos. That's important to consider kasi mukhang walang agreement ng profit sharing eh. So pag ganyan, pag walang agreement, titingnan mo agad yung capital contribution ng mga partners. The partnership realized profits in the amount of 100,000 pesos. So the question is, how shall the partnership distribute such profits? So si A, B, and C shall receive 20,000 pesos, si B, 30,000 pesos, at saka si C, 50,000 pesos. Paano kinuha yung amount niyan, class? No? Ratio and proportion, class, no? Kaya kung makikita nyo sa Colatilla, no sa 20,000, it's 200,000 pesos divided by 1 million. Saan galing yung 200,000 pesos? Eh di doon sa contribution ni A, which is given in the problem. 200,000 divided by 1 million. Bakit 1 million? Kasi yun yung total contribution ng mga partners, ng mga capitalist partners. No? So itong 200,000 divided by 1 million, saan mo siya i-multiply? Eh di doon sa profits, kasi yun yung paghahatian eh. No? So 200,000 pesos divided by 1 million times 100,000 pesos, no? It equals 20,000 pesos. So yan yung computation class, no? So, I hope this is clear, all right? So kapag walang agreement, class, no? Kasi number one palagi, susundin palagi yung agreement ng mga partners dun sa profit sharing. Kapag walang agreement sa profit sharing, then ito yung gagawin. Depende dun sa share sa partnership capital. Now let's talk about distribution of losses, no? Tapos na tayo sa profits, losses naman. Let's say lugi, no? Nag-business ka pero lugi. Imbes na kumita ka sa isang taon, nalugi ka. Does it happen, class? Yes, it happens. All right? So the first rule is the partners share the losses according to their agreement. Any agreement to exclude one or more partners except an industrial partner from any share in the losses is void. Remember this class, no? Hindi pwedeng i-exclude ang isang partner except an industrial partner sa share sa losses. Alright? Kasi class, yung industrial partner kasi, wala naman siyang contribution eh. No? Wala naman siyang contribution. So kumbaga parang walang kakaltasin sa kanya, no? Unless of course class, ibang usapan to ha. Iba yung distribution of losses doon sa let's say nalugi na yung let's say sinarado na yung partnership business. Tapos may liabilities pa rin sa creditors, no? Sa ganung usapan, pwede na habulin ang industrial partner doon. With the industrial partners, separate properties. Okay, class? I hope that's clear. Ha? Dito sa distribution of losses, hindi kasama ang industrial partner. Pero kapag sarado na ang business, tapos naghahabol na ang mga creditors, pwede na habulin pareho ang capitalist partner at saka yung industrial partner on their separate properties. Okay? If there is no agreement as to sharing of losses, but there is agreement as to sharing of profits, the same agreement as to sharing of profits will be followed as to the sharing of losses. However, the industrial partner shall not be liable for losses. O class, malinaw, no? Pag merong agreement sa profit sharing, tapos kasama doon yung industrial partner, syempre, no? Hindi na gagamitin sa sharing ng losses. Pero hindi mo isasama doon yung industrial partner. Magugulo ba ang computation ng class? Mahirap ba yung computation nun? The answer is no. Hindi naman mahirap yung computation nun. Tatanggalin mo lang yung ratio tatanggalin mo lang yung ratio ng industrial partner. All right? Example, A, B, C, and D formed a partnership whereby each of them except D contributed 100,000 pesos. D is an industrial partner. They agreed to distribute profits among them at a ratio of 20%, 20%, 20%, and 40% respectively. The partnership suffered losses in the amount of 100,000 pesos. All right? So paano yung distribution nito? Mag-share ba dapat dito si industrial partner? The answer is no. Hindi mag-share yung industrial partner sa losses. So si A, B, and C shall suffer 33,333. Lahat sila pantay-pantay, 33,333 pantay-pantay. So tinanggal lang yung ratio ng industrial partner. Okay, class? So it's not really hard to compute, no? Tatanggalin mo lang yung ratio ng and come up with a new ratio and proportion. So distribution of losses, no? If there is no agreement as to sharing of losses nor any profit sharing agreement, the losses shall be borne by the partners in proportion to their capital contributions, but the industrial partner shall not share in the losses. Example, A, B, and C formed a partnership whereby each of them contributed 200,000 pesos, 300,000 pesos, and 500,000 pesos respectively. D was admitted as an industrial partner. The partnership suffered losses in the amount of 100,000 pesos. So paano hatian? So ratio and proportionally tayo based on capital contribution class, no? So A, B, and C shall suffer 20,000 pesos, 30,000 pesos, and 50,000 pesos respectively. So how did we arrive at these amounts? So, so ratio and proportion ng mga capital contributions. So 200,000 pesos na share ni A divided by 1 million pesos times 100,000 pesos na losses and so on, no? So may computation dito kung paano nakuha yung amounts na yon. And the designation of profits and losses cannot be entrusted to one of the partners because that will be absurd class, no? Magiging bias yung isang partner na kapag siya yung pwede mamili kung paano yung hatian, no? Kasi pwedeng sabihin niya, teka, gusto ko, let's say tatlo yung partners, no? Gusto ko 98% sa akin, tapos kayo tig 1% lang kayo. Hindi mo pwedeng ganun class, no? Pero kapag pumayag naman yung ibang partners, what's to prevent that, no? Pumayag sila eh. So this is to prevent impartiality. A third person may designate profits and losses sharing provided that there is a common consent by the partners. So para sa para sa obliquo nyo class, parang may ganyang situation din, no? Yung condition depends upon the third person. No, parang ganun sa oblicon. Pag ganun pwede 'yon. Yung fulfillment ng condition depends upon a third person, pwede. Pero kapag yung condition, kapag yung fulfillment ng condition depends upon the sole will of the debtor, bawal 'yon. The obligation becomes void, right? So a third person may designate profits and losses sharing provided that there is common consent by the partners. So, sabihin, so bago ma-designate yung third person, no? Bago mapangalanan yung third person na magde-designate ng profit and losses sharing, dapat paig muna yung mga partners. Kapag hindi sila pumayag, hindi pwede. So what is the binding force of designation by the third person and the sharing of profits and losses? So it is binding unless it is manifestly inequitable. So class, no? So ano naman siya? Binding naman siya. So isabihin parang it's enforceable in court, no? Unless it is manifestly inequitable. But what is manifestly inequitable? This is a circumstantial matter. All right? Case-to-case basis yan. What is a manifestly inequitable amount? No? Or manifestly inequitable share? Kasi pag ang share ng partners, kapag ang sharing ng partners is, let's say 10%, 10%, 10%, tapos may isa 40%, it depends on the circumstances class, no? So it's a case-to-case basis bago mo matawag na manifestly inequitable yan. Tapos here's an important rule class, no? The partner can no longer complain after he has begun execution thereof or after 3 months from the time he had knowledge of the designation by the third person. So saan galing yung 3 months class, no? Yung 3 months, yan ang sabi ng batas mismo. That's what's written on your book. That's what is expressly written on Article 1798. So please read your books, no? Because the said partner is already guilty of estoppel. What is estoppel class, no? You learned in Oblicon what estoppel is. Estoppel is you are precluded from using as a defense, no? Because of your acts and actions, na you are precluded from using this as a defense. So for example, class, no? In this situation, let's say ang profit sharing ko lang ay 10%, no? So ang ginawa ko for yung sa first profit sharing, nangolekta na ako ng 10%. Di ako ngayon pwede magreklamo. Teka, kulang to. Dapat magbayad pa kayo. Tumanggap na ako eh, no? So dapat di mo na siya tinanggap or what, no? So isa pa class, no? Let's say what if alam ko na yung profit sharing pero 3 months na lumipas, hindi ako nagrereklamo. hindi na ako pwede magreklamo, class. Because I am already guilty of estoppel, and also, it's as if parang pumayag na ako or ni-ratify ko na yung designation. Alright? Kasi 3 months na lumipas na wala akong ginagawa, na parang inaccept ko na lang yung profit sharing ratio na yan. Alright? So class, remember itong 3 months, no? Na pwede ka magreklamo kapag tingin mo unfair yung designation ng third person. Itong 3 months class, no, it only applies kapag merong third person na nagde-designate ng profits and losses sharing sa mga partners. So any stipulation excluding a partner from any share of profits or losses is void. So we already know what void is from our oblicon. No, it contravenes the very purpose of a partnership contract, which is profit sharing among the partners. Alright? So hindi mo pwede exclude ang isang partner sa pag-share ng profits. Pag sa losses, pwede mo ba exclude ang isang capitalist partner? The answer is no. Pero pwede mo ba exclude ang isang industrial partner? Well, the answer is yes. Okay? Even if the stipulation is void, the partnership still subsists. It is treated as if there was no agreement as to profit sharing at all. Alright? So paano kung nasa profit sharing agreement, yung isang partner hindi mag-share sa profits? Ibig sabihin ba nun, void yung partnership contract? The answer is no, may partnership pa rin. Ngayon, paano yung hatian? And yung hatian, based on sa capital contribution, it's as if walang profit sharing agreement or losses sharing agreement. So doon ko ulit mag-base sa capital contribution. Only an industrial partner may be stipulated to be exempt from sharing and partnership losses because he cannot withdraw the work or labor already done by him. So what are the rights and obligations with respect to management? Unless the partnership agreement provides otherwise, each partner has a right to an equal voice in the conduct and management of the partnership business, regardless of the amount of capital contribution or services rendered. The partners may select a managing partner and appoint him either in the articles of partnership or, number 2, after the constitution of the partnership. All right? So class, what is the articles of partnership? It contains the very agreement of the parties, of the partners to enter into a contract of partnership. Required ba to sa isang partnership class? Before ba magkaroon ng partnership contract, kailangan ba ng articles of partnership? The answer is no. Alright? Kahit walang articles of partnership, pwede magkaroon ng partnership. Because a partnership contract is only consensual. All you need is the consent of the partners. Alright? So paano kapag yung managing partner nakalagay na sa articles of partnership? Paano naman kapag ginawa lang siyang managing partner after the constitution of the partnership? So iba yung treatment niyan. And we will talk about that today. No? So appointment as manager and the articles of partnership. So isabihin ito, unang-una pa lang nasa articles of partnership, yung appointment ng managing partner. So in this case, the managing partner may execute all acts of administration. So class, remember, no? All acts of administration. Iba yan sa acts of dominion. Ang acts of administration, ito yung mga day-to-day activities. Let's say ang business ng partnership computer shop, ito yung pagtanggap ng bayad, pag-deposit sa bangko, ito yung pag-asikaso ng mga computers, etc. Alright? Paano kapag gusto magbenta Paano kapag gusto ibenta yung gusto ibenta yung business mismo? Pwede ba yung gawin ng managing partner? The answer is no. Alright? Hindi porke managing partner ka, pwede mo na gawin lahat. Ang pwede mo lang gawin ay acts of administration. Alright? So kapag yung appointment ng managing partner ay nasa articles of partnership, the managing partner may execute all acts of administration, notwithstanding the opposition of the other partners, unless he acts in bad faith. So, ibig sabihin, class, kahit ayaw ng ibang partners dun sa decision nung managing partner, assuming it's an act of administration, walang magagawa yung ibang partners. Alright? Unless the managing partner acts in bad faith. Alright? Ano ba example niya? Let's say ginawa yun ng ng managing partner kasi galit siya sa sa partnership. Gusto niya malugi yung partnership, ganyan. Na halatang-halata naman. Yun, may bad faith yun. His power is revocable. Oh, class, no? Kapag managing partner ka nga sa partnership, tapos appointed ka dun sa articles of partnership pa lang, forever na ba yung mo? Forever na ba yung power mo as managing partner? The answer is no, class. Walang forever. Okay? His power is revocable only upon just and lawful cause and upon the vote of the partners representing the controlling interest. So class, importante itong wording, the controlling interest. It means that more than 50% of the partnership capital. So dito class, no, hindi sabihin na magbobotohan yung mga partners na kung ilan sila, ganun. Hindi ganun. Because what is the determining factor here is the controlling interest. Pwedeng sa isang tao lang yan. Pwedeng isa sa mga partners, meron siyang, let's say, 60% share ng partnership capital. O, edi siya yung masusunod. Necessarily ba siya ang managing partner? The answer is no. Paano kapag siya yung paano kapag siya yung managing partner? Paano kapag siya yung managing partner mismo? Sabi dito class, partners representing controlling interest. Wala magagawa yung ibang partners, no? Kasi nasabi sa batas eh. Nasabi sa batas, pwede lang siya tanggalin upon the vote of the partners representing the controlling interest, which is more than 50% of the partnership capital. Alright? Paano kapag yung managing partner, siya may-ari ng 60% ng partnership business, anong partnership capital? Di wala, siya talaga, siya ang managing partner talaga. What you can do is, hindi umalis ka sa partnership kung ayaw mo. Now, this is appointment as manager after the constitution of the partnership. It is merely a simple contract of agency, no? Yung managing partner. The appointment is not a condition of entering into the contract. So, kung partner ka, no? If you're another partner aside from the managing partner, all right? Yung appointment ng managing partner is not a condition of you entering into the contract. Kasi class, kapag nasa articles of partnership, para pupayag ka, no, teka, ito yung managing partner. So, ibig sabihin, ngayon pa lang, talagang payag ako na managing partner siya. Alright? So, the management may be revoked at any time for any cause whatsoever. Alright? For any cause whatsoever. By a vote representing the controlling interest. So, class, controlling interest pa rin yun yung nagmamatter. But at this time, it can be for any cause whatsoever. Yung sa kanina, kapag nasa articles of partnership, dapat only upon just and lawful cause. Alright? What is just and lawful? So, it's a circumstantial thing, no? Pwede mo sabihin na, teka, yung kasi, yung managing partner kasi, ulyanin na or whatever. I'm sorry for the term class, no? I know that we're not supposed to use these terms anymore. No? Let's say medyo hard na of remembering, yung managing partner. So, yeah, pwede na palitan yan. But of course, dapat may vote pa rin ng partners representing the controlling interest. Alright? So naman, kapag yung appointment as managing partners after the constitution of the partnership, it can be for any cause, but kailangan pa rin ng vote representing the controlling interest. So what is the scope of power of a managing partner? The general rule is all the necessary and incidental powers to carry out the object of the partnership in the transaction of the business. The exceptions are when the powers of the manager are specifically restricted or expressly withheld, and when the manager cannot exercise powers, the manager cannot exercise powers which are neither necessary nor incidental to carry out the object of the partnership. All right? So let's remember the general rule, no? Na yung managing partner, so basta lahat ng necessary and incidental powers to carry out the object of the partnership in the transaction of its business. No? So yun yung mga bagay na pwede niyang gawin. No? Hindi na pwede gawin is kapag limited yung pwede niya gawin as agreed upon. So ito yun, no? When the powers of the manager are specifically restricted or expressly withheld. Kapag express yung agreement ng mga partners na ito lang ang pwede gawin ng partner na yun, yun lang ang pwede na gawin. And the manager cannot exercise powers which are neither necessary nor incidental to carry out the object of the partnership. Let's say labas na sa negosyo ng partnership business. wala nang karapatan doon yung managing partner. Alright. So what are the powers of two or more managing partners? So in this case, class, no, there are two or more managing partners. Mas madali ba yun, class, pag kapag maraming managing partners, mas madali ba yun sa buhay ng partnership? Of course, it depends, no? There's no clear answer to that. Alright, gaya nga ng sabi natin, kapag mag-isa ka lang sa trabaho mo, mabilis mo magagawa ang trabaho mo. Pero pag marami kang kasama, the theory there is, mas malayo ang mararating mo. Pag marami kang kasama or kapag may kasama ka, mas malayo ang mararating mo. So, powers of two or more managing partners, when respective duties are not specified. Each managing partner may separately perform acts of administration. If one or more of the managing partners shall oppose the acts of the others, then the decision of the majority will prevail. O class, take note here, no? Dito, mag-matter naman yung dami ng mga partners, no? So dito, per head class eh. Let's say, it only applies kapag there are two or more managing partners. Paano kapag merong isang managing partner na hindi na gusto yung decision ng isang managing partner? Magbobotohan class yung mga partners depending sa number ng partners, not the controlling interest yet. Yung sa kanina, di ba? Yung sa kanina, kapag isa lang yung managing partner, tapos gusto mo siyang tanggalin yung managing partner na yon na nag-iisa lang, kailangan mo ng vote ng controlling interest. Alright? Pero in this case, when there are two or more managing partners, ang unang botohan muna is per head. Depende sa dami ng mga partners. Yung mga partners mismo magbobotohan. Hindi mo muna papansinin yung interest nila sa partnership, yung capital contribution nila sa partnership. Hindi muna papansinin yun. No? So in this case, kapag there are two or more managing partners, tapos meron nag-oppose na isa pang managing partner, magbobotohan muna yung mga partners, depende sa bilang nila. In case of a tie, the matter will be decided by the vote of the partners owning the controlling interest. So we know what controlling interest is, no? More than 50% share of the partnership capital. Alright? Kasi parang lumalabas na talagang malaki yung interest sa partnership. Parang halos siya na yung may-ari ng partnership, but that would be wrong, no? Because all the partners have a share in the partnership. So what if when respective duties are specified? When respective duties are specified, the decision of the managing partner shall prevail subject only to the limitation that he should act in good faith, no? Kapag ginawa naman talaga ng managing partner yung trabaho niya, it will prevail. Let's say klaro yung roles ng bawat managing partner. Kapag yun ang decision niya, yun ang masusunod, no? Kapag specified yung mga pwede na gawin. Pero dapat in good faith yun. So what are the rules when the manner of management has not been agreed upon? Posible ba, class, na sa isang partnership walang designated kung sino yung managing partner? Yes, it's possible. Pag ganyan, all partners are considered managers. All right? All of the partners will be considered agents, and whatever they may do alone shall bind the partnership, subject to any timely opposition by any partner. So it's as if parang yung kanina, no, na maraming managing partners. So in this case, parang ganun din. The matter shall first be decided by majority vote per head. If there is a tie, the matter shall be decided by the partners representing the controlling interest. Number 2, unanimous consent is required for any important alteration in immovable property of the partnership. So class, what do we mean by unanimous? So dapat lahat, no? Dapat lahat ng partners. But the consent may be expressed or implied. Well, let's say yung ibang partners naman, hindi naman sila nag-o-object. No? So class, importante to. No? Let's say you go to court. Tapos let's say maging lawyer kayo. No? Tapos may sinasabi na yung kalabang lawyer, yung kalabang party, may sinasabi na hindi na gusto. You cannot just stay silent. No? You have to object. You have to raise your hand and object. Magreklamo kayo. So any important alteration in the immovable property of the partnership is an act of strict dominion. So class, again, you have to be able to distinguish between acts of administration and acts of strict dominion. Ang acts of strict dominion, let's say, binebenta mo na yung lupa kung nasan yung partnership business, o binebenta mo na mismo yung partnership business mismo. Acts of dominion yan, class, no? Kasi hindi naman yan yung regular na business ng partnership. So yun, no? So any important alteration is an act of strict dominion, not an act of administration. Therefore, even the managing partner cannot act by himself. He needs the consent of all the partners. So what class is a contract of subpartnership? So a partner may associate another person with him in his share without the consent of the other partners. That other person is called a subpartner. Subpartnership agreements do not in any way affect the partnership. The subpartner does not acquire the rights of a subpartner. Rather, this should be the subpartner does not acquire the rights of a partner. So I'll have to edit this class. No, please forgive me. Later na. So so this should be a partner, no? So yan. So the subpartner does not acquire the rights of a partner. He is also not liable for debts of the partnership. The subpartner does not become a member of the partnership unless he is accepted to be such by all the partners, and the subpartner agrees to be a partner. So ano ba ang subpartner class, no? For example, ako, partner ako sa partnership along with A, B, C, and D. So 5 kami, no? Let's say ako, kailangan ko ng pera, no? Medyo wala rin yung partnership ko kasi, yung partnership magkikitain pera in the future. So magkakaroon ng profit sharing in the future. Ako naman, class, kailangan ko let's say kailangan ko umutang, parang ganun. Ang promise ko dun sa isang tao, sa stranger, teka, magkakaroon naman ng profit sharing yung partnership business namin. Baka pwede na pautangin mo ako ngayon, tapos ang ipambabayad ko na lang sa'yo, yung makukuha ko dun sa profit sharing ng partnership. Let's say partner ako ng magandang law firm, kunwari. No? Tapos magkakaroon ng profit sharing. So yung share ko dun sa partnership profits, naka-assign yun, mapupunta yun dun sa stranger na yun, na inutangan ko. So ang tawag sa kanya, sub-partner. Pwede ba, class, na yung sub-partner, pwede ba siya mangialam sa partnership business? The answer is no. Wala siyang personality sa partnership business, hindi siya pwede makialam. Hindi siya pwede magyabang doon, teka, sub-partner ako. Dapat may say ako dito kung paano nyo ginagawa ang business nyo. Hindi pwede yun, class. Alright? Yung sub-partner, pwede na siya maging partner kapag pumayag yung lahat ng partners. At saka, syempre, kapag payag yung sub-partner na maging partner. Kapag hindi pwede. Alright? Parang ano lang yan, class, na let's say, umutang ka, tapos sinangla mo yung lupa mo. Tapos yung pinagsanglaan mo, he acts as if he is the owner of the property. No? Parang nagtatayo ng negosyo, ganyan. Hindi dapat ganun. No? Unless it's your agreement, of course. In the same manner, class, no? Yung sub-partner, hindi pwedeng makialam sa partnership business. Alright? Ang interest lang niya is yung share mo dun sa magiging profit sharing, yung share mo dun sa profit sharing, no? Parang as a partner, you are associating that sub-partner only as regards the profit sharing. Alright? And class, no? So every partner is accountable as a fiduciary. So pag fiduciary, it involves trust and confidence. Let's say may tinanggap kang pera for the partnership, hindi mo pwedeng suluhin yan, hindi mo pwedeng ibulsa yan. You have to account it for the benefit of all the other partners. All right? So duty to act for common benefit. Any partner cannot, at the expense or the detriment of the other partners, use or apply exclusively to his own individual benefit the partnership assets or the results of the knowledge and information gained by him in the partnership. All right? So class, whatever yung partnership assets, it has to be accounted for the partnership. Hindi yan pwedeng suluhin ng mga partners in their individual capacities. Duty number 2, duty to account for earnings accruing even after the termination of the partnership. The partner is duty bound to account such profit or commission with his co-partners. Number three, duty to account for earnings accruing even after termination of the partnership. So kahit tapos na yung partnership, dapat ay ano pa rin, dapat ay ano pa rin, dapat accountable pa rin yung partner, no? Number four, duty to make full disclosure of information affecting the partnership. So right of capitalist partner to engage in business. For a while class naman umulit pala. Let me change this. Number three should be number two should be duty to account for secret and similar profits. No, let me change this. For a while class, I will just change this. Class, no, kapag yung partner may nakuha siyang secret and similar secret profits, kasi may nagbayad bigla, no? Kahit sobrang nangangailangan siya ng pera, hindi na pwedeng gamitin yun for himself, no? He has to account such profit or commission with his co-partners. All right? So right of capitalist partner to engage in business. So class, medyo na pag-usapan na natin to kanina. The prohibition against the capitalist partner to engage in business is relative. Unlike the prohibition against the industrial partner, who is absolutely prohibited from engaging in any business. Alright, pag industrial partner, talagang bawal kahit anong business yan. Pag capitalist partner class, bawal lang siya mag-engage ng business which is of the same or similar kind of business as the partnership. No? Prohibition applies only to a business which is the same as or similar to the business of the partnership. Any capitalist partner violating this prohibition shall bring to the common fund of the partnership any profits derived by him from the business. In case of losses, the offending capitalist partner shall bear them alone. So class, paano kapag yung capitalist partner, let's say ang business ng partnership is computer shop. Yung capitalist partner, nagtayo rin ng business na computer shop. So may conflict of interest ba? Yes, mayroong conflict of interest. Alright? So class, pag ginawa yun ng capitalist partner, tapos hindi naman siya pinayagan ng partnership, ano mangyayari? Yung profits ng business niya, pwede kunin ng partnership yun. Paano kung nalugi naman yung business niya? O hindi naman mag-share pa yung partnership doon. Kapag nalugi yung business niya, kapag nalugi yun, yung capitalist partner lang yung mag-bear ng loss. Pero kapag kumita, yun, pwede kunin ng partnership yung profits. Okay, class. This ends our lecture for today. So please stand by for the next lecture videos. Please stay safe. Take care.